Welcome. Welcome to A Taste of Justice. I am Professor Angela May Kupenda. This is a short today. I am recording it to help my students who are enrolled in my First Amendment course this semester, but I'm recording it for all of us who are concerned about our constitutional rights, and this semester, specifically, our rights under the First Amendment, our speech rights. All interpretations here are my own, but for informational purposes, I will tell you, I am a professor of law at Mississippi College School of Law. I've been teaching in law schools and business schools now for about 30 years. Now let's get right to it. What I want to do today is to remind you of a rule I told you about in the earlier clip, and then introduce you to another rule. Okay, so first, the reminder. Pure speech is protected from content regulation by the government unless the government satisfies a very high level of scrutiny, or unless the pure speech is in a category of unprotected speech. Now, in another clip, I do a bit of an overview of those categories, and in the text box, I've given you the link if you want to get that overview in advance. For now, we're going to talk about the first category of unprotected speech. If speech falls in the category of unprotected speech, government may regulate, restrict it more. Okay, so the first category is called speech that advocates illegal action. Now, you may say, what does that mean? What does it mean for speech to advocate illegal action? Because you want to know, because if your speech falls in that category, government may regulate, restrict, or punish it more. So what I want to do here is I want to start with what is considered to be the modern day test to determine if your speech is in that category. Then I want to mention some of the historical cases, and then ask you, is it possible that the court is going to change that test, or is it likely that the test will be changed? Now, speech that advocates illegal action, the case that gives us the legal test to determine if that is so is called Brandenburg versus Ohio, a Supreme Court case decided in 1969. And I give you the name of the case typed out in the text box below. So what happened in that case? A member of the KKK did an interview for a news station. And in that interview, the KKK member made some derogatory comments about Black people, and then said some things like, if the government continues to suppress the white race, it's possible that there might be some revenge. The speaker also said that the group had planned to march on Congress, to march in Florida, and also to send a group to Mississippi, where I am, right? So there were some other comments too. So the speaker was convicted for that speech, with the government saying that the speech was advocating illegal action. So the speaker appealed to, and the case went to the US Supreme Court. ultimately. Now, what did the court hold? The court held that the speaker's speech was protected speech, was protected under the Constitution. The court indicated a somewhat new test for speech that advocates illegal action. Let me read the test to you. The court said that in order to show that the KKK member's speech was unprotected, was speech that advocated illegal action, the government would have to show that the speech was advocacy directed to inciting or producing imminent lawless action and is likely to incite or produce such action. And I've typed the words below so you can think on them. Now, the court held that the KKK members' speech did not meet this test. Therefore, the court said his speech did not fall in the unprotected category, and his conviction could not stand for that speech. Now, one of the justices issued a concurring opinion. Here, the justice was essentially agreeing that this speech should be protected, but he wanted to add an additional comment. And what the justice said was the historical cases that we will talk about in a minute. The justice said the historical cases were crushing the rights of ordinary people to protest, like the speaker in this case. Then he pointed out that the KKK speech could not be restricted here, as it was not a time of national war, but it was days of peace. What do you think about that? In Mississippi in the 1960s, days of peace. But that is what the court held. This test that was articulated is called the Brandenburg test, and you use that test to determine if the speech is unprotected. Now, what are these historical cases that the court was concerned about? Now, in a longer clip, I go through all of those at length. I've given you the link below if you want to learn more about that or read more about that in the text box. But essentially, in the historical cases, the court was, I guess you would say, the court was more likely to find that the speech was unprotected. Let me give you some examples. So there was one case where speakers went to a recruitment center, and it was during a mandatory draft for war. The speakers tried to persuade the individuals who were there to sign up that they should not sign up. Now, there was no evidence that their speech actually led to anyone refusing or declining to sign up. But still, the court upheld the convictions of the speakers. The court said things like, free speech is not absolute. The court also said, when a nation is at war, many things that may be said during times of peace are no longer protected. The court also, in the historical cases, upheld the sentence of some individuals who were teaching things from books that were readily available in the library. And the court actually upheld the convictions of some men who threw some leaflets, some anti-military leaflets out of the window of a tall building in New York. That was one of their means of distribution of their message. So these historical cases, in the historical cases, it appears that the test was broader in terms of what speech is unprotected speech, or what speech is more likely to be determined to be speech that advocates illegal action, that the historical cases perhaps were less protective of speech than the Brandenburg modern day test. Now, my final question for you is, I want to say, what about today? What about during our times today? Do you think that we should revert back to the historical cases and give government more leeway to punish speech? Or do you think the Brandenburg test ought to continue to be the test that is used by the court? Remember, the Brandenburg test is more protective of speech. Let me ask you, what if the case involved foreign terrorism? Do you think that the Brandenburg test should apply, more protective of speech? Or should the court go back to the historical cases that gave government more power to suppress speech? What if it was not an instance of foreign terrorism? What if it were an instance of domestic terrorism and speech advocating that domestic terrorism? Do you think that the Brandenburg test, more protective of speech, ought to apply still? Or do you think the court should go back to the historical cases and use a test that gives government more leeway in restricting speech? Those are questions for you to think about. Remember, this is supposed to be a short, right? Oh my, I've given you the links if you want to hear more about those questions I just posed for you. Look, remember, learning is a path to enlightenment. Enlightenment to freedom, freedom to justice, or at least to a taste of justice. So subscribe and sign up for notifications so you don't miss a thing. Next week, in about a week, I'm going to do a short review of the second category of unprotected speech we're going to discuss in my class, and that is defamation. You take care. Bye.